2014. Started his profession in the capital market team of, I really hope I pronounce it correctly, Luthra Law, and offices in New Delhi for a year. He then joined the Vatva Law Chambers. After a short, albeit rich experience of 1 year in trial court advocacy at Vatva Legal Chambers, he made the leap as an associate at Haitane Core, and after around 6 years, he joined the dispute resolution vertical of Saraf Partners, which is the current law firm as far as I understood, and he's currently serving as the principal associate of the same team with a rich experience of about 10 years in handling complex corporate commercial litigations with special focus on insolvency and bankruptcy across various courts and tribunals in India. So our current guest has been regularly advising a number of individual and corporate clients in matters on a broad range of corporate commercial issues involving companies, acts, and insolvency and bankruptcy code. Additionally, Aditya handled arbitration spanning over various sectors, including construction, investment, and automobile. His strategic clarity allows him to deploy appropriate tactics to achieve the desired outcomes for his notable clientele. So please welcome our today's guest, Mr. Aditya Vikram Singh.
Thank you, Professor Alexi. Respected Aditya Vikram Singh sir, Professor Karan Kataria, Professor Rajat, and my dear fellow friends, good afternoon and greetings to all of you present here. It is indeed my pleasure to welcome all of you to the first flagship expert series of the India Policy Forum. I would begin with the words of Dale Carnegie. There are always three speeches. For one you actually give, the one you practiced, the one you gave, and the one you wish to give. I certainly don't know which one is coming today. So let me begin by laying forth about our forum. Sir, the India Policy Forum is an emerging initiative by the students of the OP Jindal Global University. We hosted our inaugural event on February 20th, 2024 this year, where Professor Dr. C. Rajkumar, founding Vice Chancellor of OP Jindal Global University, Professor Dr. Anirudh Rajput, distinguished academician, Sri Rajiv Kumar, Indian economist and former Vice Chairman of Niti Aayog, Professor Karan Latyan, Chief Proctor, and Professor Dr. Mohan Kumar were present and graced the event through intellectually sparked conversation with the student body of JJU. We at India Policy Forum have a strong vision to bring Bharat's glory out into the world as leaders of the Global South amidst the changing world order. IPF is a channel for students to engage in discourse on Indian social, economic, and political issues. We aim to become a value-based network that thrives off the Bharatiya spirit while inculcating the aspirations of country in active research, discussion, and debate. I want to extend my heartfelt regards to Professor S.G. Srijit, Executive Dean of Jindal Global Law School, for his constant support and invaluable guidance. His invisible guiding hands were helping me at every rung of the ladder. The theme for today's discussion is interplay of arbitration and insolvency in an Indian scenario. The Arbitration Act 1996 and the Insolvency Bankruptcy Code have been the most significant legislation which have drove India's economic spirit of ease of doing business. Traditional insolvency regimes lacked arbitration flexibility and efficiency. IBC thrives to provide a stressed and ailing debtor a calming period by staying actions already initiated and pending or yet to be initiated against the debtor. This is termed as moratorium period in the Indian legal way and in the Indian code. Section 14 ensures maximization of value of assets of the corporate debtor by staying all action against them. Where the arbitration regime seeks to provide the parties with a choice of a private forum for resolving the disputes, the insolvency regime seeks to provide a central adjudication for creditors of the corporate debtor. Hence, the issue of arbitrability of insolvency disputes comes for the determination before the court. Arbitration is a private adjudicatory process through which parties decide to forego their right to approach the courts in favor of arbitral tribunal. Hence, it is necessary that it should be ousted in cases where erga omnes effect, that is, rights for against everyone concerned, are present. The collision between arbitration and insolvency has been globally recognized. This explains why some jurisdictions such as US and UK are much more settled in this regard, and they have adopted interpretations that minimizes the impact of such collisions. Since prior to IBC, there was no full-fledged statutory insolvency process in India that could compare with the insolvency regime. However, since 2016, India too has witnessed these concerns, requiring the balancing of interest of arbitration and insolvency. The most common methods adopted globally for minimizing the effect of this collision is based on the idea of segregating the disputes which lie exclusively in the domain of insolvency court from the disputes which may continue to be adjudicated. The approaches can be categorized in three ways: creating a distinction between a core and non-core way, in a non-core insolvency dispute; second, analyzing a dispute based on its rem and in personam character; third, analyzing a dispute based on its impact on the debtor, disputes being either beneficial or prejudicial to the debtor, and reserving only such disputes for the insolvency courts. Sir, you discussed the test of dressed up petition in your paper, which could be an effective way to deal with an insolvency application filed with an ulterior motive. And I'm sure that you will discuss that in your speech as well. A similar applicability to proceedings in the court would require the adjudicating authority to find if an application under the garb of insolvency seeks to avoid the arbitration clause. However, this approach also comes with certain contention. Although none of these approaches, which I just mentioned, have been statutorily recognized by the Insolvency Code, thereby considering India's unique legal space that is outward and open to global developments, one approach can be to follow beneficial actions to a corporate debtor and subordinate in personam disputes to continue, while applying global standards on a case-to-case basis. So without further ado, let's call Aditya Vikram Singh sir for his insights on the same. Floor is all yours, sir. Thank you.
Thank you, Professor. Thank you, Mansha, for the introduction. Okay. Now, before I start the session today, I would like to raise the topic of the session through some discussion, because the topic that we have chosen today is interplay between the Arbitration Act and the Insolvency Code. Now, why is there an interplay? That's something which we need to discuss and answer, because both of these statutes are actually working in a distinct manner, discussing and also providing for provisions and the way remedy can be provided by the court or through the tribunals in a different manner. But as you would recall that all these commercial statutes are dealing with certain commercial relations. Whenever there is a commercial relation between the parties, there would be certainly probability of some kind of dispute that would come in. And in most regard, you would find that these disputes and these commercial relations between the parties actually pertain to either an operational creditor or a financial creditor. I would come to the concept of the other creditor later. But look at all kind of commercial contract that exists today. There would be a contract, say, for a construction project. The contractor is providing services to the government or the owner of the project. What is this project about? This project would be about construction of a road, construction of a building, for instance, construction of this university. This is the contract for work which is nothing but operational in nature. You go to a shop, you purchase grocery or you purchase any item from the store. These are for operational purposes. Now I'm saying that even the smallest of the transaction that we do in day-to-day life is in a manner commercial in nature, can be categorized either in the category of a financial debt or a commercial or a operational debt that you incur. So far as financial debt, that aspect is concerned, obviously there are so many transactions that we undertake from bank, financial institutions, even otherwise between two persons lending money to each other. There would definitely be some transactions which are not within the category or characterization of an operational or a financial debt. Those could be in the nature of, say, a shareholder purchasing shares in a company. You cannot strictly characterize that transaction as a operational or a financial debt or a financial credit. So the Insolvency and Bankruptcy Code specifically provide that right to initiate insolvency proceeding for a default only to two kinds of creditor. Either he has to be a financial creditor or it has to be a operational creditor. So you have to prove that there is a default in payment of operational debt or a financial debt. I'm hoping that most of the students here have gone through at least the courses on arbitration or insolvency, or otherwise would have interned and researched on the aspect of insolvency and arbitration. These concepts of operational debt and financial debt is pretty much clear to everyone, I hope, and I will start from that. Now, whenever there is a dispute that is arising, whether it's in the category of a dispute between a financial creditor and a financial debtor, or an operational debtor or an operational creditor, which I believe largely 80 or 90% of transactions, commercial transactions, can be covered into these two categories. There would be a dispute and parties have their right to either exercise the right under the Insolvency Code for a default, or if there is an arbitration clause in their commercial contract, they can definitely exercise that right and invoke arbitration in terms of the Arbitration Act. Now, what is important is one party is dealing with multiple parties for its day-to-day business. For instance, a factory would require loan from a bank, would also require its vendors to supply raw materials. So far as vendors are concerned, those are operational debt. So far as bank is concerned, that's the financial debt. It is not necessary that these disputes will arise at different points in time. A lot of these disputes actually arise simultaneously, and in that scenario, when there is an operational creditor, for instance, a vendor who wants to exercise his rights under the commercial contract by invoking arbitration, there could be a bank or a lender who wants to exercise its rights under the Insolvency and Bankruptcy Code and file a Section 7 petition. It may also happen that the vendor wants to exercise his rights in terms of the Insolvency and Bankruptcy Code. Probably a NBFC lender would want to exercise its rights under the contract and invoke arbitration against you. It's on the creditor to choose their rights and claim their dues. But when these things are happening, these things definitely bring in a scenario where there could be some kind of conflict between the rights which are being exercised by the two sets of creditors. There is another interesting scenario or another segment that we should think of. It's not always necessary that a creditor is exercising the right. It could also be a situation where a debtor wants to exercise its rights. For instance, I am running a factory and I have taken loan. I have taken loan from lender. There are certain requirements that even a lender is required to follow. There are certain preconditions. I'm going back. Is it not audible at the back? Sorry. When a party is trying to enforce his rights under an award and say that, I have got a quantified amount of say 1 crore rupees, and the award debtor is not making the payment, he has two rights. One, he can go for enforcement of the award, that he could do so under the Arbitration Act. The other one is to choose his action and initiate a proceeding in terms of the Insolvency and Bankruptcy Code. While deciding to choose an action under the Insolvency and Bankruptcy Code, how does he prove to the court whether he or she or the entity can be classified as an operational creditor or a financial creditor? There have been various case laws, various judicial precedents which have adjudicated on this issue. A lot of time when consent awards have come in an arbitration proceeding, where the parties have agreed that certain amount is payable by one person to the other, from the debtor to the claimant. In such cases, there are court rulings where it says that it doesn't amount to a financial debt. It may be in the category of an operational debt. There are other kind of rulings which say that it neither amounts to a financial debt or an operational debt. But there is some sort of finality in this position. You would see that there is a case that I have cited in this Cholamandalam investment case, which is supposed to be having the best kind of reasoning to understand the situation. The court has asked the parties to look into the underlying agreement, the underlying contract. If the underlying contract is of the nature of an operational debt, it would definitely qualify to be an operational debt. If the underlying contract is that of a lending agreement between the parties, it will qualify to be a financial agreement, financial debt. So far as this categorization of creditor on the basis of an award is concerned, this is the holding of the court, and we must look at the underlying agreement to understand the relation between the parties. And then on the basis of that understanding, a party can initiate his rights and action under either Section 7 for a financial creditor or under Section 9 for an operational creditor under the code. But there are other complicated issues when we are talking about the interplay. This is only at the stage of pre-admission, when the parties are choosing their action after an arbitration award. But I'm largely focusing on an issue where the dispute is not arising after an arbitration award, but the focus is on where a dispute has arisen and the parties have to choose an action, either under arbitration or under insolvency. Now, this situation becomes a lot more complicated for the reason that there is something called moratorium under Section 14 of the Insolvency Code. As Mansha said in the opening remarks that, about moratorium, that it's a bar on initiation or continuation of any proceeding against a corporate debtor. But when does this bar operate? This bar actually operates at a time when a corporate debtor is admitted into insolvency. It's not that once you have filed a petition for initiation of insolvency proceeding that a moratorium kicks in. The NCLT, which is the adjudicating authority for this purpose, needs to decide the issue whether there exists a default of payment of financial debt or operational debt or not. And therefore, this is something which is not arbitrable once the insolvency, once a debtor is admitted into insolvency, because it becomes a action in rem. And Booz Allen is the Supreme Court judgment which talks about certain carve-outs and the matters in which arbitration or an arbitrator cannot adjudicate upon. Similar to insolvency, there is other one, say a family matter, a divorce dispute. In divorce dispute, an arbitrator cannot adjudicate. However, there are other disputes related to, say, a family affair where if parties have agreed to go into arbitration, definitely they can choose and go into arbitration. But certainly Booz Allen provides for certain carve-outs what cannot be dealt by the arbitration. But here we are talking about those disputes which are equally capable of being pursued into insolvency or under the Arbitration Act. Now it's important to read section 14 of the Insolvency and Bankruptcy Code to understand the real purport of the legislation. Now section 14 of the Insolvency Code says that subject to the provision of subsection 2 and 3 on the insolvency commencement date. On the insolvency commencement date is basically the date on which a corporate debtor is admitted into insolvency. Why? Because NCLT or the adjudicating authority has found that there is a default in payment of an operational debt or a financial debt. The adjudicating authority shall by order declare moratorium for prohibiting all the following, namely institution of suits or continuation of pending suits or proceedings against the corporate debtor, including execution of any judgment, decree or order in any court of law, tribunal, arbitration panel or any authority. Now this is quite a wide bar which is imposed. So once a corporate debtor is admitted into insolvency, you can't institute an action against it of any nature, and you cannot also enforce any decree or an arbitration award. In such situation, it's very important to understand that there are certain proceedings which a corporate debtor may also initiate. The real meaning of moratorium is any proceeding which is going to dissipate the value of the corporate debtor, the assets of the corporate debtor. Now, any action, for instance, for recovery action against a corporate debtor where corporate debtor is liable to make any payment, or there is an award which has come and it is required to be enforced. The corporate debtor is required to make payment in order to comply with the award. In all these cases, what is happening is during the insolvency proceeding, the corporate debtor would have to dissipate its assets, make payment to a certain person who is claiming. However, the corporate debtor is now under an in rem proceeding of insolvency. It's a proceeding against the corporate debtor for all creditors at large, whoever has any claim against the corporate debtor. If such a situation arises, if a corporate debtor starts making payment to these different entities, it will end up in a situation where certain entities or certain creditors are being paid. However, it doesn't, and corporate debtor doesn't end with sufficient amount for payment of remaining creditors. Therefore, moratorium protects that action during this phase. You cannot initiate proceeding, you cannot enforce award, you cannot enforce decree. However, there are certain exceptions to it. And those exceptions are in a situation where a corporate debtor, through its resolution professional, and I hope everyone understands the duty and obligation of a resolution professional. A resolution professional, inter alia, is also supposed to ensure that the asset of corporate debtor is maximized. And maximization can take place also by initiating action on behalf of corporate debtor for any amount which is due to the corporate debtor from a debtor of the corporate debtor. Let's not confuse, I mean, there is too much of debtor, creditor. So I'll just break it down for better understanding. A corporate debtor, while it owes a lot of amount to a lot of creditors, also stands as a creditor to a lot of debtors, because it's ultimately also providing or supplying services or selling goods to other people. Now, insofar as those actions are concerned where corporate debtor is going to benefit out of those proceedings, those are not barred by moratorium. And therefore, a situation may arise where a resolution professional on behalf of the corporate debtor initiates an action against its debtor for recovery. And it can do so because moratorium doesn't prevent it. But what happens to a counterclaim by such debtor against the corporate debtor? Because every relation is not one-sided. There are mutual dealing between the parties. For instance, if a corporate debtor has supplied certain services or goods to a debtor and it wants to gain out of that transaction, wants to recover amount, it may also happen that the said party would have given certain advance amount and wants a kind of set off, which corporate debtor is saying that, there is a moratorium, whatever advance amount that you have given, but I need to recover my dues. I will not pay you. In those kind of situation, the Delhi High Court has held a view, the NCLAT has also held a similar view, that a counterclaim in an arbitration which is invoked by a corporate debtor will not be barred. So as long as a corporate debtor through its resolution professional can exercise his rights to initiate a recovery action against its debtor, a counterclaim by such a party against the corporate debtor cannot be barred, because ultimately we need to focus on two issues. One, merely continuing with a proceeding of an arbitration does not dissipate the value of the assets of the corporate debtor. Ultimately, it may so happen that an award comes against the corporate debtor. At that time when it's enforced, the corporate debtor would have to make the payment. And in such cases, Delhi High Court has held that you continue the proceeding, because without taking into account the counterclaim of the other party, court is not in the right condition or a right situation to determine or quantify the amount which is payable to the corporate debtor. So in such a situation, it's important to adjudicate on a claim in an arbitration along with a counterclaim in an arbitration. And those kind of counterclaim cannot be barred by moratorium. That's the view that the Delhi High Court has taken. And I don't see that there is any issue with that kind of view. However, Supreme Court in another judgment, which will come later, P. Mohan Raj, says that that understanding is flawed and that cannot be done. However, in my understanding, the Supreme Court has not looked into one important aspect that Delhi High Court and the NCLAT has looked into. In those kind of proceeding where Delhi High Court or the NCLAT, which is the National Company Law Appellate Tribunal, has allowed a proceeding to continue even on a counterclaim, are those proceedings where an arbitration was initiated before commencement of insolvency, before commencement of moratorium. And therefore, in such cases when a recovery action is continuing on behalf of the corporate debtor, those action can also be continued for a counterclaim. However, insofar as the Supreme Court judgment is concerned, it strictly says that initiation of a counterclaim during moratorium should not be allowed, because a counterclaim is as much a proceeding in terms of Section 14 as any other proceeding that could be initiated for recovery. There would be divergent position on this, but I see that there are claims and counterclaims which are being adjudicated together even during moratorium period. Now, other issue that I wanted to discuss was the stages where these issues crop up. One is the stage of pre-admission, which is before the moratorium kicks in, and a stage of post-admission, which is basically where in-rem proceeding of insolvency has started, and then what action can be taken or barred against the corporate debtor. Now, in this regard, let's imagine a situation, one of the examples that I had given earlier, the example of there is a claim of a creditor against the corporate debtor, and there is also a counterclaim by the corporate debtor against such a creditor. I had briefly talked about a situation where lender is under an obligation to disburse payment in a segregated manner because the lender has not complied with the obligation under the lending agreement. Therefore, or henceforth, the default of corporate debtor actually kicked in. In such a situation where we are at a pre-admission stage and the creditor has filed for insolvency proceeding against the corporate debtor, does the corporate debtor have a right to say that there is an arbitration agreement between the lender and the CD, corporate debtor, and therefore kindly refer this matter to an arbitration, which is a right under Section 8 of the Arbitration Act. Section 8 of Arbitration Act says that where there exists an arbitration agreement and court has a very limited role, a very narrow role as per the decision of this court, that so long as there exists an arbitration agreement, the subject matter of dispute is covered under it. It needs to be referred to the arbitration. There are exceptions to it. The exception is that insolvency being a statutory right given to a creditor, it can choose either to go for an arbitration or exercise the statutory right. But divorce that fact. The point is, insolvency proceeding in terms of IBC is summary in nature. There is a very limited exercise of adjudication which happens here. There are affidavits which are filed where evidences are not led in detail. The NCLT, which is the adjudicating authority, does not adjudicate on the issue of what is the amount which is due and payable. What are the other amounts which cannot be paid? What is the dispute arising out of? All of those issues which can only be discovered and found and adjudicated upon in a detailed evidence exercise which happens either before a civil court or before an arbitration tribunal. Therefore, there is always that risk that one runs while initiating an insolvency proceeding, because the tribunal in terms of the IB code is only required to make an adjudication whether there exists a default, and that's a very limited exercise to be done, and it's not holistic trial or holistic examination of all disputes between the parties. And it's also one-sided. It's a creditor who's claiming. The debtor may have have limited defenses. For instance, in a Section 9 operational creditor case, the corporate debtor would only have a defense that there is a pre-existing dispute, that there is a dispute which started before a notice in terms of Form 3 of the IB code was issued, that there is a default. Or in financial debt, there is another very limited defense that it has, that the debt is not payable. Now, for all these issues, it's in fact required that a court goes into a detailed examination, which is not necessarily possible at the stage of IB code at Section 7 or a Section 9 stage. Now, in such cases, Indus Biotech, a Supreme Court judgment that I have referred in the slide, what it says is, here, Kotak India Venture Offshore Limited was claiming to be a financial creditor, and Indus Biotech was the corporate debtor. There were certain amounts which were liable to be paid by Indus Biotech to Kotak. Kotak exercised its rights under the insolvency code in terms of Section 7, that it's a financial creditor, there is a default in terms of payment, and therefore Indus Biotech is liable to make the payment. What Indus Biotech did was it filed a Section 8 Arbitration Act petition before the NCLT, saying that there exists a valid arbitration agreement, and therefore this dispute ought to be referred to the arbitration rather being tried before or adjudicated by the insolvency code, which is NCLT. What Supreme Court did was quite unusual, or also quite interesting in that way, because it held that first the NCLT would have to look into the insolvency petition. If there exists a default, the insolvency petition ought to be admitted and moratorium will kick in. Now, when that happens, the Section 8 petition under the Arbitration Act, which is filed by the corporate debtor, in this case Indus Biotech, that will stand dismissed without any adjudication on merit. Now, this becomes a one-directional affair, an affair where one party is exercising all rights, and the corporate debtor is mostly in a most adversarial position. But this is the law that stands today, that whenever there is a Section 8 petition under the Arbitration Act which is filed for reference of a dispute to arbitration, because there is a valid arbitration agreement, that is not required to be adjudicated by the NCLT. Rather, a limited exercise which is required under Section 7 or Section 9 is required to be done by the NCLT to find whether there exists a default or not. On that limited issue, if there is a default, the corporate debtor is admitted into insolvency. This is the story pre-admission stage. But what happens when corporate debtor actually gets admitted into insolvency? This issue becomes complicated, because even after commencement of insolvency, as I said, during moratorium, no proceeding or a suit or an action can be brought against the corporate debtor. Doesn't mean that the corporate debtor cannot bring an action against the other person. So in such a situation, though Indus Biotech's Section 8 for reference of dispute to arbitration was not allowed, can it exercise its right under Section 11 of the Arbitration Act, which is basically that, I have a valid arbitration agreement, the other party is not agreeing for appointment or cooperating in conducting the arbitration proceeding. In such a situation, the court must appoint an arbitrator so that the arbitrator panel can decide my overall issue, overall dispute, even after moratorium has kicked in. There are certain judgments where courts have held that, in a manner, the dismissal of Section 8 petition, which was filed before commencement of arbitration, would also act as a precedent for a Section 11. And therefore, if Section 8 is dismissed, your Section 11 would also be dismissed. Now you see the kind of cascading effect that it has. Your Section 8 cannot be adjudicated because first the NCLT needs to decide the insolvency petition under Section 7 or Section 9. But then after initiation of insolvency, when Section 11 is sought to be initiated and arbitration is sought to be started by appointment of an arbitrator in terms of Section 11 by the court, that gets dismissed because Section 8 was dismissed. So it becomes quite a circular thing which happens, that Section 7 gets decided against the corporate debtor, its Section 8 gets dismissed because Section 7 got admitted, and the Section 11 subsequently gets dismissed because Section 8 was dismissed. Now this is a situation which I found to be quite funny, and I wrote an article on this which got published in Indian Arbitration Law Review, where I have taken up a alternate view of dressed up petition, which was earlier applied by Company Law Board, which is the earlier avatar of the NCLT. Those things are not there in this slide. I missed to write those, but I'll just explain about it. As Mansha also mentioned about dressed up petition, that's a concept where a court really looks into the ulterior objective of a petition. Now, if a petition has actually been filed for ulterior motive, for instance, I'll go back to my earlier example. The lender has faltered in his obligation, but in order to avoid any counterblast or a counteraction by the corporate debtor, it takes the first step. and initiates the insolvency proceeding against the corporate debtor, so that it goes into insolvency, and after that corporate debtor does not have any right to come back. So it becomes a unidirectional affair of deciding issues only in favor of a certain party. Maybe, may not be, but in most likelihood it could be. Now in such a situation, my proposal is that court should look into the ulterior motive, even in a summary stage where NCLT is to decide only on whether there exists a default in terms of section 7 or 9. The NCLT should also, upon being pointed out by the corporate debtor that there are certain ulterior motive of the creditor, should look into those issues and first decide whether the petition is actually a genuine petition or not. In this regard, there is a judgment which was given by Justice Indrani Banerjee of the Supreme Court in Vidarbha. In Vidarbha, she held that if every petition is going to be admitted without looking into the real affairs of the company, whether it's actually an insolvent company or not, you will end up even pushing a company which is otherwise solvent, but because there exists a default in one minor agreement, one creditor's agreement somewhere here and there, it gets admitted into insolvency and the entire management is chucked out. The affairs is then conducted by a resolution professional. Now in such a situation, she had proposed an idea of overall looking into the affairs of the company and also examining whether it's really a solvent company or not by looking into the financials of the company and seeing whether there are certain dues and payable to the corporate debtor or not. Now, those kind of things could be adopted by the NCLT in order to ensure that the proceedings which are initiated with ulterior motive are not given way. This counterclaim portion I have already discussed. There are certain judgments that I was referring to. Now, certainly there are claims which are initiated by the corporate debtor during moratorium. Let's come back to a stage where it's post-admission. Pre-admission I have already discussed. And now in a post-admission situation, can an arbitration proceeding be initiated against the corporate debtor? There is also another factum that I would like to discuss is once an arbitration award has come, it could be either against the corporate debtor or against the creditor, whatever it may be. Can a 34, which is basically an objection against the award, be filed or could be continued or initiated? That's another issue. Courts are of the view that one, you cannot continue or initiate any proceeding against the corporate debtor. This also includes that you cannot initiate or continue an objection to an award that has come against a counterparty. So far as proceedings post-moratorium is concerned, post-admission is concerned, the limited affair that could continue against the corporate debtor during the moratorium phase is one, an arbitration proceeding which was continuing or started before admission, and after admission, those claims and counterclaims, claims by the other party and claim by the corporate debtor which is continuing after moratorium can also be adjudicated and continued along with the counterclaim of the other party. In relation to 34, which is objection to an award under the Arbitration Act, if the counterparty, basically I'm referring to counterparty as a party who is not the corporate debtor. So if a counterparty has initiated, is aggrieved of an award that has come against it, can always continue with the section 34 action before the court. But there is a catch. The catch is that the courts have held that section 34 can be decided, but it cannot be enforced. So an award may be upheld or rejected, but if it's upheld against the corporate debtor, you cannot enforce it against the corporate debtor during the moratorium period, because enforcement again will come back to the same situation where the concept of acting against the maximization of the value of assets of the corporate debtor will come in. So in those cases, there are limited exceptions created for a Section 34 continuation or an arbitration continuation, but it's not an absolute bar. There are situations where a 34 or a arbitration can continue against the corporate debtor even post-admission stage, but we will have to examine on each and every fact and situation as to whether it can continue or not. And the only test is to what extent is it going to impact the value of the assets of the corporate debtor. And the last topic that I wanted to touch upon is generally in terms of the IB code, in terms of the statute, an insolvency proceeding is required to be completed within a period of 180 days. 2 extensions can be granted, and even after all extensions that could be granted, it ought to be completed within 330 days. Now in practicality, it doesn't really happen because most of the insolvency proceeding actually take longer than 330 days. It goes on for 2 years, 3 years. I'm actually working on 2 of the transactions, 2 of the matters where insolvency proceeding has been continuing for the last 4 years. So though the statute provides that it should be in a time-bound manner completed, but it doesn't really happen. But what happens once the CIRP proceeding is completed? There is 60 subsection 6 of the insolvency code that says that the entire time period that has undergone into an insolvency proceeding, that time period is required to be excluded from computation of limitation period. So for instance, if a corporate debtor is admitted into insolvency in say 2018, from 2018 till 2024, the proceeding is continued. And because of that moratorium, the other party is not able to bring an action for recovery of its money or in whatever manner against the corporate debtor. In such a situation, once the CIRP is terminated, the party can bring an action, even if it's a 2018, even if it's a claim which is arising in 2018, the entire period of 6 years can be excluded while computing the limitation period. However, this is not an absolute principle where any action which was prevailing prior to initiation of insolvency could be brought back after completion of the CIRP period. Because the resolution also has an impact. The resolution process ultimately extinguishes all monetary claims which are against the corporate debtor. So any action which existed prior to commencement of insolvency, which is monetary in nature, is extinguished or provided for in terms of a resolution plan under the IB code. Once a resolution plan has provided for it, that is supposed to have been extinguished, and you cannot bring an action after completion of the CIRP. However, there are certain kind of proceedings which does not get extinguished during the CIRP period, and those kind of proceedings are those actions which are in the nature of specific performance, which are not monetary in nature. For instance, there is an action which is arising out of a sale deed. A party has entered into a sale deed and it's still not giving, so corporate debtor has entered into a sale deed. It is required to hand over the possession in terms of sale deed to the other party, but it has gone into insolvency, and now after completion of insolvency, it cannot claim that, I have gone through the entire period of insolvency, all my liabilities are extinguished, and I am not required to hand over the property back. Such kind of issues, such kind of actions, even after completion of insolvency process, can be brought in, and insolvency and the entire period which has undergone into completion of insolvency process has to be excluded while computing the limitation. Now, these are the basic portions and facets of interplay between arbitration and insolvency code that I wanted to cover. There are a lot more issues, but I think that would take a lot more longer sessions. So I would conclude here, and I would open for question and answer session.
If anybody has questions, we can maybe pass on the mic through.
Good evening, sir, and thank you so much for this wonderful session. So my question was regarding the Kotak judgment which the Supreme Court gave. You mentioned how the statute says that the creditor has the option either of going via the NCLT route, the IBC route, or the arbitration
Correct.
route. But then the court imposed that if there is a valid arbitration agreement, it should, even if there's a valid arbitration agreement, it should first look into the insolvency part and reject the arbitration, the arbitration provision which is there in the
Correct.
contract.
Correct.
So this contradiction, is there this defect? How does it affect in the practicalities of matter, and is it biased towards any of the parties?
No, so the answer that has been given by the court is section 238, which is the overriding effect of insolvency code. That's number one. And number two, it's always the a plaintiff who has the right to choose an action. If he has chosen an action to go a certain way, obviously that's a statutory right under insolvency code. He has exercised that right. But 238 is a better answer, which has an overriding effect. So even if he has chosen something that he has to go through, if creditor has chosen to initiate insolvency process and the other party, which is the corporate debtor, is saying that there exists a valid arbitration agreement, therefore it should be referred to arbitration, 238 comes into picture, and because of those reasons and those other reasoning, that Kotak judgment was decided in that manner. However, I agree with you. I see an issue and I pointed out those issues with you.
Thank you, sir.
It's on now. Yeah, sir, another aspect that I was hoping that you could shed some light on was about the treatment of contingent claims in IBC. Because a lot of time that happens is that the resolution professional allots a notional value of INR 1, and then just to even the odds, they just balance the scales and then continue the proceedings as is.
Correct.
So
Correct.
I just wanted to get some clarity on how does that relate to arbitration as well, because in substance an arbitration is a contingent claim itself, because the outcome is not yet certain.
Correct.
So if you could shed some clarity on that aspect, that would be great.
So, see, let's trifurcate this issue. And so the first aspect is there is a claim that exists against the corporate debtor. Now, that claim, because there is a pending arbitration proceeding which cannot be continued during the post-admission phase, it really doesn't reach a conclusion. If it doesn't reach a conclusion, there is no quantification of that debt. What amount is really payable by the corporate debtor to the creditor? In that situation, you would recall that in terms of the IB code, all claims are required to be filed before the resolution professional. And the resolution professional is not an adjudicating authority or an arbitration tribunal. He only verifies the claim. And the verification process, practically how it happens is, the resolution professional would open the books of the corporate debtor, see whether books of the corporate debtor really reflect certain dues to a certain creditor or not. If it really reflects those kind of dues in relation to a certain creditor, it admits the entire portion. But if the financials and books of the corporate debtor itself shows that this is a contingent claim subject to a arbitration proceeding or a, say, commercial suit or civil suit, in such cases, would you think that it is correct on the part of resolution professional to admit that claim by adjudicating the entire amount? No, in my view, this is the amount which is payable, so I would not admit a claim of 1 rupee, but I would admit the entire claim of the operational creditor or a financial creditor. Now, there comes the tricky part, because the resolution professional doesn't really have that right or power to adjudicate over a claim, and he's only exercising the function of verifying a claim. He has to, and he must admit such contingent claim at INR 1. or any other amount which he thinks is correct to be admitted, but he cannot really quantify that amount. And therefore, the Committee of Credit for SR Steel versus, I think, Satish Kumar Gupta, in that case, if you see para 97, 98 onwards, it answers that question. The Supreme Court says that such contingent claim ought to be admitted at 1 rupee, and there is no issue with it. So, I mean, I agree with your, the issue that you have raised, that it should not be done in that manner. But during the insolvency process, the only person who is actually verifying the claim is a resolution professional, not a court of law, not a civil court, not a commercial court, not an arbitration tribunal, because all of those are barred in terms of moratorium. So because this limited option is available, this is the solution that probably from commercial perspective, the applicants and professionals have found, and this is how it is being practiced.
Good evening, sir. So my question was with respect to personal guarantors. So now personal guarantors are included in the IBC proceedings. So will there be any
Personal guarantor to a corporate debtor,
corporate debtor? Yeah.
and
So
not otherwise.
yeah. So my question.
Those provisions are still to be notified that way.
Okay. So is arbitration proceeding an option for them as well, or is it not a possibility when it comes to personal guarantors?
See, invoking any right for initiating arbitration is subject to the agreement
Right.
that a party has signed. If there exists an arbitration agreement, there is a choice to initiate arbitration. But then, at what stage you are invoking that right? And especially when the creditor has chosen, for instance, a personal guarantor is now required to make certain payment as a debtor. You know, personal guarantee has been invoked. And after invocation of personal guarantee, the creditor has made the first move of initiating an insolvency proceeding against him. Now what do? In terms of Indus Biotech, court will actually have to adjudicate on that insolvency petition. And even if there is a desire of the personal guarantor to initiate an arbitration or get the entire dispute subject matter referred to the arbitration, that will have to be decided only if only if the personal guarantor insolvency is not admitted, right? And there is also another facet to personal guarantor. In personal guarantor situation, you would have read the provisions of the court, 95 onwards. There is a concept of interim moratorium, which does not exist in the in companies' cases, right? So the moment a petition is filed, interim moratorium kicks in. Adjudication may happen at a subsequent event, and thereafter a moratorium can continue, which will not be an interim moratorium. So to answer your question, there could be a desire, but Indus Biotech needs to be followed in that situation.
Hello, sir. Very good evening to you. My question today has to do with a little bit of your paper that I read and also the talk that you gave. So it's related to adjudicating authority and counterclaims. So what I wanted to know was, say a counterclaim is found out when the case is in proceeding under the adjudicating authority. Then in that case, does that case move to a civil court, or like do the proceedings continue under the adjudicating authority itself?
No, I think. So there is a counterclaim which could be filed before the arbitral tribunal, not adjudicating authority.
No.
I'm confused about your question. So you are saying that there is a insolvency petition that has been filed against a corporate debtor.
Yeah.
Now when that is filed, the corporate debtor has a counterclaim which cannot be filed before the NCLT, because NCLT is not the forum to file it. There could be a situation where a corporate debtor really has a counterclaim, and for that purpose it has filed a Section 8 Arbitration Act petition to refer the dispute to the arbitral tribunal. Or there could be another situation where there is already an arbitration proceeding which has been initiated by the corporate debtor. Probably you are referring to that kind of situation where insolvency proceeding has already been initiated by the corporate debtor and there are claims and counterclaims. In the mid of the proceeding, the creditor has decided to choose an option that he wants to go through an insolvency way and abandon the process of arbitration Is that the situation?
Yeah, basically. Like I think I'm so sorry I put the question.
No, so in that situation, again, the test of dressed up petition can help because that question arises out of the article that you read. So in dressed up petition, the court can actually see, the intent of the creditor, that the creditor and debtor were already into an arbitration proceeding. And during the process, the creditor realized that probably this could be a far-fetched game. It may turn out in his favor, not in his favor. It's going to be a detailed examination of both sides' case. So in such a situation, court can take a view, but strictly speaking, I think even after that process, even if the creditor exercises the right at that later stage, the NCLT may or may not admit, and NCLT will have to look into that case independent of what was going on.
Thank you, sir.
And especially in Indian context, most of these arbitration and a civil suit or commercial suit takes a lot more longer. In Delhi, commercial suits take shortest amount of time, I think 1.5 years to 2.5 years. But otherwise, if you talk about any other jurisdiction, especially Bombay, it may take 5 to 6 years.
Oh.
So creditor generally exercises that right of insolvency rather than approaching a commercial court or a civil court. Yeah, Arya?
I had a question, sir. Are you?
Please ask.
Can I? Okay. Where the clear and marketable title of the asset of a corporate debtor is under proceeding, would that proceeding be exempted from the moratorium? Because wouldn't it be in the interest of getting a value maximized?
Your question is about title-related suit against the corporate debtor or by the corporate debtor?
By the corporate debtor. Because
So, as I said, even during moratorium, any action by the corporate debtor can continue or can be initiated by the resolution professional on behalf of the corporate debtor.
and what if it is the other way around?
If it's the other way around, because this is not a monetary claim per se, and as per the code, it cannot be extinguished. So it may have to wait for the duration of the CIRP, but it can be continued thereafter.
But sir,
during
wouldn't it
the
be-
process, going by Delhi High Court judgment, I would say it can be continued because it's really not impacting during the process, right? And ultimately, whether the property is in the corporate debtor holds the valid title in the property or not is a question which cannot be adjudicated upon by the NCLT and has to be decided by a court competent to do it, right?
Thank you.
Thank you for this session. Sir, my question pertains to the practical management of how do you see a corporate debtor and its creditors would go on with this from a pre-existing agreement perspective, because ideally a corporate debtor would want to minimize the risk of whether the creditor will go for insolvency, or because I have entered an arbitration agreement as well, but if I run the risk of them ignoring that and going for insolvency petition, then how's that risk being optimized, if for a better word? If it is a multi-tier agreement to say that please do this before that, would that not be hit by 23 and 28 of the Contract Act to say that, if I say that I'll put layers before you go for an insolvency petition?
No, I think putting in a layer can probably work better in cases of operational creditor for sure, because in those kind of cases, when NCLT as the adjudicating authority comes down to adjudicate on the issue whether there exists a default or not, it will have to see whether the default exists in terms of the agreement that has been signed. Unlike a financial debt, where there is a clear-cut, obligation to make the repayment, and there are mostly clear-cut timelines of payment, which is called, amortization schedule. So in terms of that, there is a default, then there is a default. You can't help it. But in cases of operational creditor, if there is a multi-layered agreement that you are referring to, I think that would be a very good idea, and a lot of people are actually doing it these days.
If I may just follow up, anything else that is being done just to minimize this risk?
The other thing that generally gets, in terms of advice to the corporate debtors, be proactive in initiating actions for settlement, because once you are entering into settlement dialogue, you can hold on the action against you, right? And as long as it's going in a more involved manner, the creditor would never file it unless he has to create some kind of pressure on you. Now I have filed insolvency. Now you come and sit in the across the table and decide this. You must make the payment. Now till that, I think once you initiate a settlement dialogue, I think that could work very well.
I think we had one more question. Oh, okay.
So you mentioned dressed up petitions, and you said that the ulterior motive of the petition has to be taken into account, and the matters of the company has to be taken into account.
It doesn't get taken into account, but I
You
think
relied
it
on the
should be.
Vidarbha case, but that was overruled by M. Suresh Reddy, right? That
You are right.
restricted
That
Vidarbha's
is also given in the
application
slide.
to,
That's not overruled. That
it
that only
restricted it to its
that
current
only-
facts, that the arbitral award in favor of the corporate debtor must exceed the debt. Only in those cases they'll they'll use the discretionary power of NCLT under Section 7
Correct.
and let the application be admitted.
Correct.
Then how do you defend your point of dressed up petitions in such a context when the Supreme Court has said that it's only restricted to that set of facts?
That's a very good question. What I really propose is, so no court has really used or applied dressed up petition in insolvency matter so far. That's a test which arises out of the erstwhile company law board issues where there used to be mismanagement petitions filed only in order to ensure that the matter does not go into arbitration, because again mismanagement related reliefs were so wide in nature that could only be given in by the NCLT by the CLBs those days, right? And in those kind of situation where CLBs used to find that the parties trying to avoid the arbitration scenario, in those cases mismanagement petition used to be dismissed and parties used to be referred to the arbitration. So that concept, that test arises from those cases, yet to be applied or may not ever be applied in insolvency cases. But my dressed up petition test here does not really is subject to whether the corporate debtor has more claim against the creditor or creditor has more claim against the corporate debtor. It should be applied in either manner, because you are ultimately deciding on ulterior motive. Because see, Vidarbha also is not on ulterior motive. It's only on deciding and determining the insolvency, whether the company is really insolvent or not. So to that extent, I think, my ideas are also sort of abstract, and there is no concrete thing that I could share.
Understood, sir.
So with that, we will wrap up. Sir, thank you so much for your insights on that. We are a policy-based forum, and I believe these economic legislation play a pivotal role in India's development because I think business and law, they go hand in hand. Thank you so much, everyone, for being an engaging audience. I would now request the convener of the society, Jagdish Trivedi, to give vote of thanks.
Thank you so much.
Thank you.
Good evening, everyone. As the convener of the India Policy Forum, I am honored to extend our heartfelt gratitude to everyone who contributed to the success of today's discussion on the interplay of insolvency and arbitration proceedings. First and foremost, our special thanks to you, Mr. Aditya Vikram Singh Sir, Principal Associate at Saraf and Partners, for graciously leading today's insightful discussion. Your expertise and valuable insights on this intricate topic have enriched our understanding and sparked meaningful conversations. I would also like to thank all the students who attended today's event. Your active participation and eagerness to learn have made this discussion even more engaging and impactful. We hope that the knowledge gained today will serve as a valuable resource for your academic and professional journeys. Behind every successful event, there is a dedicated team working tirelessly to ensure everything runs smoothly. I want to express my deepest gratitude to our organizing committee, volunteers, and staff for their hard work, dedication, and commitment to excellence. Your efforts have not gone unnoticed, and we are truly thankful for all that you do. In closing, let us carry forward the insights and knowledge gained from today's discussion and continue to engage in constructive dialogues that contribute to the development and improvement of our legal system. Thank you once again, and we eagerly look forward to hosting you at our upcoming events. I would now request Professor Alexi and Professor Rajat to felicitate the guest with Jeju Memento and token. Thank you.
We have snacks waiting for you outside, so